I want to take the opportunity to go through the contract with you, but I'm going to tell you that I have really a very limited experience in dealing with the entire contract. Usually when I get involved, it's because I get a call from Pam or one of the agents that says that this is going on in my transaction, and I'll say, well, what does the contract say? And so I kind of zone in, narrow down to whatever that one focus is, right? Typically, it has to do with inspection clauses, right? Time of the essence issues, closing dates. I mean, there are certain things that I get repeatedly, most frequently asked questions, right? So, but we're going to take an opportunity today, since it's new, to go through the contract line by line. Now, I will tell you that the primary changes are really about clarification and definition. You know what I mean? It's about clarifying the old contract. There are some new terms in there, but a lot of it is just to provide more clarity for what is meant or what the parties have to do. So we're going to start now with the paragraph 1, which is the property description. Now this is the marked up version of the contract, so it shows the new, the new and what's being stricken. So if it's being stricken, of course, it's going to have a line through the actual letters and numbers right there, and then if it's old, it's going to have a strike through. If it's new, it's going to be underlined. Right? We're going to be looking at the highlighted language. In the property description there, you can see in yellow how they've added to the property description that you're also supposed to now put in the auditor's parcel numbers. That's to make sure that the property address and the parcel numbers are going to be consistent. If there's more than one parcel number, like lot 1 and a side lot 2, then you have to make sure that whatever's being transferred, sold, both parcel numbers or as many parcel numbers as you have need to go in there along with the address. I've seen this maybe in situations where there's been like a large tract of land, like a farm, that they've now broken up into parcels, but it had one property address. Remember, the whole purpose of a contract anyway is to provide clarity for the parties and an understanding as to what they're agreeing to. So you want to do the big picture and the narrow picture for them and make all that just as clear as possible so that there aren't questions about what is the agreement, right? So the agreement is I'm buying this property at this address, which is what generally they know, right? And then the particulars are going to be the parcel numbers. If you don't have enough room, that's when you want to use an addendum to say that, to explain it. So you go back and say paragraph 1 shall include these parcel numbers. So 2, timelines. The most important thing here about timelines is something that's not bolded, which is this part here that talks about time is of the essence in regard to every date in this contract now. So time is of the essence in every aspect of this contract. The whole purpose of a contract is to get to the end. You don't want any surprises. You want the transaction that you've agreed to actually take place. But things happen, right, through no fault of the individual parties. And unfortunately, you're going to see this throughout this contract, that because time is of the essence, there are numerous places where this contract can go afoul, right? And it's really putting a lot of responsibility on buyer and seller agents to try to get this contract through, right? Making sure that everybody's doing what they're supposed to do. Because once it's time is of the essence, if you don't hit that date that's specified, if it says 3 days is all you have, 4th day the contract's breached. In some places it's going to say that the contract is automatically terminated, so you're going to see that. Or it's automatically null and void if certain things don't happen. Which means, kaput, all the hard work that everybody did on both sides. The buyer who really, really, really wanted the property and went above and beyond trying to strike the right deal and make the best offer, gone. So really important that everybody learn that about the new contract. Dates matter, times matter, right? And of course, contract performance dates and contingencies, everything starts the day following the day you get the agreement, right? That's not new. Earnest money contingencies, right? So this is going to be, this is important here because this is now telling you that time is of the essence in getting the earnest money in. right? And so you have to say not only the amount that's going to be there, but you're going to have to say who's going to hold that good faith deposit. And as you know, license law says that there are restrictions on releasing that money once we have it, right? And so there's some guidelines for how it can ever be released, which basically is an agreement of the parties, right? If you want to get it back right away, you're going to have a written agreement of the parties. Separate from the contract too, okay? Because I've seen situations where people try to write it in an addendum of the contract that the good faith money is going to come back to the buyer or is going to get to the seller. Well, the contract and it's basically saying that it needs to be a separate writing. But here where it says within blank calendar days, so you can put whatever number of calendar days you want in there, but the next part there says that if you don't specify a number of days there, it's automatically going to be 3 days. But now you should never leave a blank in a contract, right? So I don't know that this was really necessary to say that if you don't put a time in there, it's going to be automatically 3 days. I mean, this is very important. It's getting that good faith deposit, right? So you want to get it as quickly as possible so that seller knows buyer's very serious, they've got money or skin in the game, right? So it's doubtful that you're going to say 2 weeks here, right? And many times the good faith deposit may even be attached with the offer. So, but the thing is you'll need to specify, if you want it to be more than 3 days, you have to specify there. You don't want to leave it blank, so I still say put 3 days in there, 2 days, whatever it is you're going to agree on. But then you have to provide a written acknowledgement that you've received it within that stated period. So, right, so at the very back, there's a receipt of earnest money kind of clause on there that you can use if you've received it at the time you're making the offer. I don't think you really want to send the whole entire offer package twice, right? You want to send the offer, you don't have it attached, so you'll just want to have a separate written acknowledgement sent, but it's required. And guess what? At any time after the stated period, but prior to receiving the written acknowledgement of deposit, the seller, at its sole option, can terminate the contract. So that's your first opportunity to have it go bye-bye because you missed that specific deadline. And that happens. I've seen it. You know, new language here, basically again, in the event that the parties do not designate an Ohio real estate broker and they designate another third party, or here in listed title company, the terms of and conditions of this escrow hold shall be governed by separate third-party escrow terms. So that's that agreement. Try to get an agreement in writing. It almost says that you should have it, and then they got this box where it says separate escrow terms are attached. Keeping in mind the parties get to make their own agreement. This is a template form that you can complete, but they might not like this, and they may say something else, so you got to be prepared for that. So this line 43 dealing with settlement charges is new, and basically for the first time they're trying to clarify what the seller actually has to pay for on the sheet in terms of, the seller's paying this and the buyer's got this. So this is specifying in the contract itself how that's going to be divvied up. So it says, in addition to costs incurred in order for the seller to fulfill the terms of the contract and to provide marketable title, seller agrees to pay actual settlement charges and other fees at closing on behalf of the buyer, including but not limited to discount points, closing prepaids, and any other fees allowed by buyer's lender, an amount not to exceed blank. Right? So that's very clear. In other words, the seller's going to provide X amount of dollars to the buyer and no more. But that's where that's going to go. Now we get to financing contingency, and this is very convoluted for me. I don't deal with lenders and mortgages daily, so I asked Mark to kind of jump in here. He's familiar with the contract, and he's familiar with the changes, so he's going to take
All right. Yeah, there's really not many changes for you guys. We got the settlement charges. That's the same. That's been in there. That's whatever they're paying. You know, whatever the seller's paying towards the buyer's costs. That's going to be on that 43. Financing contingency. I don't. That seems to be the same. Does owner-occupied rental other. The cash piece in here gives a little bit more detail. As you can see on the new one, asking for proof of funds, right? Yeah, is attached, shall be provided within so many days. So you guys know if you're doing a cash deal, you got to get the asset statements provided within so many days to the seller. And now as we go through this thing, conventional loan, that stayed the same. They added, just under the government, FHA, USDA, VA, added a bucket for USDA. That's really not a whole lot different. And it just added the language for USDA just because there is a fair amount of USDA contracts floating around out there. So it does have, just the same thing, mortgage amount, your percentage, and the rate and the term in there, and not to exceed X percentage. If you want to put that in there, or it does say in here, and I guess this has always been in there, years are at a higher rate or shorter term agreeable to the buyer. So talk to somebody and they're at 3 1/8 and the rate goes to 3 1/4. They're not going to be, we're still going to be able to do it. So let's see here. Other funding source, and I don't really know what this would be. Maybe like a OFA or something like that. But usually you'd include that underneath the FHA, the USA, or USDA FHA bucket. So I'm not sure. That might be like commercial or something else that's unusual. But usually, what we see in here is you guys do some of the OFA, the Ohio bond money, things like that. That could be listed there. Or usually, if it is a OFA loan, or some of the special, grant programs, you could list it here or put it under the conventional or FHA bucket, I would assume. So what this gets into this financing time frame again, because I know Rhonda was making a lot of reference to the times of the essence, where it says if you don't have the confirmation of the different time frames on here, then they could cancel the deal, which I think is the same as what it is now, and as Mike so eloquently alluded to, a lot of times those don't get hit. So, but if we got on here, okay, first one, qualification letter. Number one, that's the same as what's been in there before. Got to have a pre-qual letter within so many calendar days. Number two, the intent to proceed. So many calendar days. You just have to be able to provide that. And we see some of those. We don't get asked for that too often, but if we do, we're happy to provide it. It is a form that the borrower signs with their application documents, and it says, "Yeah, I agree to intend to, I intend to proceed with the application." And you got in here the approval.
75, yeah.
This is kind of an interesting thing because then under C here, let's take a look at it if you guys can't see the screen. Let's go on there. Provide written notification to the seller. Conditional approval has been obtained within so many calendar days, beginning from the day. So that essentially stays the same. They asked they added a little bit more creditworthy, a little bit more detail or meat on the approval. Underwritten with credit, income, debts, assets, collectively creditworthiness, verified and acceptable to lender, subject only to material changes. Now this would bug me as an attorney or somebody, but subject only to material changes the buyer's creditworthiness. Well, that should have been addressed up front. So I think that's kind of a weird line. I'm not sure why they added that, because I guess if somebody stops paying their bills after they've been approved, that could be a problem.
This is one of the places where you really need to understand how the lender that your buyer uses functions. Can they meet these timelines? Can they provide you with written documentation that because that's what it now requires. It now requires at each stage, after you get your initial qualification letter, you've got to send that within it's not just get it within, you've got to get the notification to them within that time frame, right? That's the big thing. So if buyer fails to provide written confirmation to seller, contract is terminated, right? So you not only have to get it, you have to get it to them. That's going to be very crucial, that you give your buyers enough time. And so you don't, I mean, I hate to say it, but the time when buyer can go look at the house and then go out and get the pre-approved, that's got to be passed, right? You've got to have all this stuff and to know who you're dealing with, even the title company that you're going to use to close, right? Because if you specify that the funds are going to go there, you have to all know all the stuff up front at the time you make your offer. So be very careful with these dates. Make sure that your client understands these are hard dates and times. They cannot miss them. So if they're going with some lender they got off the internet, they better make sure that they can get this type of documentation from them.
The other thing, this is not new. I mean, this was in the original contract. Your approval date was in the contract before. So this, it sounds like there's just a little bit more meat maybe for the seller to be able to, you guys to be able to say, hey, we don't want to take this buyer anymore. And D is new though. This is kind of interesting. It's funny because I'm talking to Bridget back here, and she's got closing Friday, and she's like, I'm not sure when we're going to have the approval. It's not with us, unfortunately, but so it's an interesting thing because saying, okay, we have to have it clear to close, has it been obtained or waived within so many days prior to the date of closing. So this is actually kind of a new thing. Rhonda was asking me what kind of date to put in there. I mean, it's really going to be up to what the lender, the type of loan, but I would expect probably, on a realistic basis with volume and everybody still being pretty busy, it's going to be 1 to 2 days, 3 days maybe. It's really whatever you guys want to put in there.
So we're going to come out after, we're going to the appraisal, appraisal contingency. So basically, I think what's here is this language on, in the event the real estate does not obtain an appraised value by either buyer's appraiser in connection with the sale, funded by cash, and then pretty much the new stuff is the other funding source. So this is just a recognition that not that it, beyond being a cash sale, it could be some other kind of funding source. Like somebody has to cash in their stocks or bonds or something, and they find that they don't have enough, that it didn't appraise. So that they didn't have enough money maybe in there, or they have to get more money. Anyway, they're going to have to make sure that if it doesn't appraise, no matter where the money's coming from, they have the right to terminate the contract. The financing contingency, it does have a box that you can check for other funding source. So if the money's coming from some other place, make sure that those are consistent there. It says buyer shall have the option to terminate the contract by delivering written notice to the seller, and they've stricken on or before the expiration time frame, blah, 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 in the event the purchase via cash or other funding source within blank calendar days beginning the day following the contract. So again, another hard deadline. They're only going to be able to terminate based on how many days you put in here. So if you've got an appraisal contingency and they've got money coming from some other funding source, right? You just got to make sure you give it enough time there that you know that you're, I'm trying to think how to say this, that you know they're going to have the funds and therefore you can waive the appraisal contingency, or that you met it. So whatever date you put in here, again, hard and fast. Yeah, so it basically just says there, when they do the scratch out the right option, it's just, they're saying that the option to terminate the contract is waived if you don't meet that contingency period. And they struck this, shall have all the utilities servicing the real estate on during the appraisal inspection, because they put it someplace else. So it's still in the contract. put it someplace else. Inclusions and exclusions of sale. This is really dealing with fixtures and what are fixtures. And the main thing that this does is to say that it doesn't really have to be a fixture to be a fixture. Sorry. But that, a slide-in range is now automatically included to be a fixture even though it's not attached anywhere. Right? So even though you can slide in. So certain appliances are now just automatically considered to be fixtures. And that's why you see a lot of the strikeout, like down here it says the following built-in appliances. Well, they're basically here in the new language says the following appliances shall also be included. So they're saying that whether it's fixed anyway or not, ranges, ovens, microwaves, refrigerators, dishwashers, garbage disposals, trash compactors are all considered to be transferred with the property, whether or not, just you don't have to say they're getting them. They're all considered to go with it, despite the fact that they're not a fix. Now, they do say that freestanding countertop appliances shall not be included unless specifically detailed. But the thing to remember about this is, if there's any question about it staying or not, make a writing separate, put it in an addendum, and make it very clear. Because I've seen situations where there's more than one refrigerator in the house, maybe 3 different refrigerators. And so they're thinking the ones in the kitchen, the other people are thinking all of them. So just make sure that you clarify here. Because this basically says they all go. So if the seller really wants to take something with them, one of those refrigerators, make sure you put in there that it's not going.
Okay, 8, paragraph, seller certification.
So this is not, I think some of this is to creating a list, more of a list format. And so it's is or is not, is or is not, is or is not. And so now it's is not subject to a lease. It is not, is or is not subject to an agreement pertaining to joint maintenance of shared aspects of the real estate, not covered by an HOA. Now, what is that? It deals with the maintenance of things that are shared by more than one property owner. But anyway, if there's something that you're sharing, you've got to specify there. That's what that's about. And again, I think some of this is just to make sure that the parties understand their obligations here, that there is a shared maintenance obligation kind of thing. So anyway, so what else is it? So is or is not subject to pending orders of any public authority, is or is not owned by a person or entity subject to the Foreign Investments and Real Estate Tax Act. I won't even say much about that. There's also another part in the contract where there's an affirmative statement, that the transferee is required to withhold some of the funds if this person is subject to this or something. That's a huge obligation for a buyer to take on. You're right. I mean, somebody says I'm not, and then they don't withhold. I don't know what happens, but it is going to be. You'll see it later. Has or has not had work performed or an improvement constructed that may result in future assessments. This was concerning for me, that this is a yes or no relative to the property having toxic, explosive, or other hazardous substances have been stored, disposed of, concealed within, or released on or from the real estate. Now, some of this is addressed in your property conditions disclosure form, and now they've reiterated it again here inside the purchase agreement. So I don't know why that was necessary to have them assert it twice, but evidently they're going to have to. Oh, and then it says no other adverse environmental conditions exist within the boundaries of the real estate. What they struck, though, was to the best of the seller's knowledge, which is different than the property conditions form. They're only required to disclose what they have actual knowledge of. But for the contract, they say no, there's no toxic substance, and then 6 months to a year later, they find mold in the house. Opportunity for litigation. right? Because they said, no, there's none. Oh, yes, there was. And they can't say, well, to the best of my knowledge, because that's been stricken. So this, unfortunately, in my estimation, is more of a warranty by putting it in the contract, which the form says, the property conditions form says that the seller in no way is warranting this, and you need to do your own investigation, right? And yet this contract is now saying that they, yes or no, just yes or no, take responsibility for yes or no. So we'll see. Let's hope that they know. It's an opportunity for a dispute, right? That's what I'm saying. That this is the very reason I'm saying I'm not sure. Ultimately, answer is going to have to come from any dispute that you get, or you get the parties to agree as to how they're going to resolve it. But I think it opens the door. So this one is yes or no to property assessments, and then there have been, yes or no, there have been improvements installed, furnished, and or seller has received notification from public authorities or owner association of future improvements, which is part of the cost may be assessed against the real estate. So again, this should be disclosed, right, on your property condition form relative to assessments that are coming. You're supposed to turn all that over. And then when you get down here to what the homeowner association condominium, they've added some stuff that creates a little bit more responsibility on part of the seller, which is to disclose currently approved or pending homeowner association assessment. So it's twice they have to say it. This is nothing new. How much they just rewritten it and reformatted it. Somewhere in here, though, it says that part of what they have to, yeah, here it is, minutes for the previous 2 years has been added. So not only the same old documents that you had to give for the homeowners association or condominium, you also have to make sure they have the minutes of the association meetings. Well, guess what? Nobody has it, but you got to get it to them within blank calendar days. So when I tell you this new contract puts a lot of responsibility on you as agents. You got to know what the deadlines are, you got to know what it is, and probably as soon as you identify the property, you're going to need to be asking these questions. How long is it going to take me to get 2 years of your minutes and all these other documents, the bylaws, the articles, the rules, the restrictions, the assessments? How long is it going to take you to get that? Because you got to make sure you've got enough calendar days in there, or guess what? Contract can be terminated. Here's some more timelines here for the buyer, because once they get all of this within the calendar days they're supposed to get it, they then have a certain number of calendar days that they have to review it and reject it, right? And then they can get out. The buyer can get out, so they can get this. They're going to have a certain number of days to review it. Now you got to think about the time it's going to take for you to collect it, to send it, to make sure that they have time to read it, right? Sufficient time to go through it and get it back to you so that you can document it and make sure you respond in writing whether basically you're going to reject it and terminate the contract. If written notice of disapproval is delivered, the disapproval, then this contract shall become null and void. Well, I think this works against your buyer. So this is a contingency for your buyer to get out. So if the buyer's okay and wants to stay, then they don't have to send over something that says we want to stay. They're going to basically waive this contingency. This is only if they look at it and they want to get out, they've got specified number of days to get that to them. Again, it's a contingency of the buyer to get out of the contract. So if they don't exercise their contingency to stay in, they don't have to send anything. It only is going, this all says, it's only about disapproval. They call it disapproval. So if they're going to disapprove of whatever the content is, then they have 3 days to get it back to the seller in writing that they're disapproving. If they don't, then they're waiving their right to terminate. So the contract will go forward. You see what I mean? So this is a contingency for the buyer. They want to stay in, no big deal. If they want to get out, they have to do it within this time frame and in writing. This line here, it says buyer shall be responsible for and seller shall reasonably assist in obtaining in the lender required documents from the association. Now the interesting thing about that is it says that the buyer has to get it, all this information, and the seller has to assist. But what happens if the assistance is not good enough and they can't get the documents, and the lender, it's lender required? And that, remember, going back to your financing contingency, the lender says, I've got to have all these documents in order to meet this timeline, and then you run into a problem here. So again, these are things that you need to consider in advance. If you're dealing with something, you're looking at a property that has a homeowners association, you've got to get all this. When you think about that when you're writing out your timeline for your financing contingencies, right? Because the lender's going to have their own version of something that they get. Well, at least for condominiums, I think it is. They have to have their own certification. They have to have their own. They usually get it, and the buyer's responsible for helping, and the seller's responsible for helping, but you're still stuck with the same timeline. Now this next section here talks about the buyer's responsible for all fees and for documents required by the lender. So if you remember, usually when the lender has to have these documents from the homeowners association, there's a cost, and they always charge that to the buyer, so that's not really new. But it's just making it clear that that is a cost to the buyer. This next paragraph, I guess right here, I've seen this worked out where it's been problematic as to who's supposed to do what and pay. But it says, at the time of closing, buyer shall pay for any initial capital infusion or advance dues assessments required by the association. So I've seen a situation where in the bylaws or the articles, anytime the property's transferred, the new buyer has to pay a certain number of months up front. So that's kind of what this is referring to, right? And the buyer would say, you should pay that. And the seller would say, no. The articles say that it comes from the buyer. So this, again, is one of these things clarifying that this is a buyer responsibility. And I don't think we need to go through exactly all it is, because it just goes through any dues assessments that relate to the period and how they're prorated and stuff. So just make sure that you understand that paragraph. But again, the costs are to the buyer. Now this maintenance provision here, I think used to kind of just relate to the house itself, the building itself. And now what they've done is they've said that it's that the seller's obligation to maintain the property is the property. It's not just the house. It might be the unattached garage or shed or whatever else might be there. They have to maintain it all until the buyer takes possession. And again, more clarification of just whose responsibility it is. Home warranty, they just putting in, just clarified, made it more simple, just specify who that is. They've struck the insurance paragraph here because they've moved it. So the buyer gets to select the company, does, or however it's going to go down, right? So either the buyer selecting or the seller selecting, but you'll have to check buyer selects or does not select. If they're not selecting a home warranty, then I guess that's not applicable. If they are selecting a home warranty, then you have to say what the company is, I think, is what the first blank would be, and then paid for by the seller or the buyer. As I said, this contract's going to require a lot more work on your behalf. So when you call about the property, if they're listing in the MLS, or maybe, hopefully people will get used to this and they'll know that they've got to fill in the name of the warranty company, so maybe they'll go ahead and put it in the MLS. The seller's offering home warranty by so-and-so. So at the time you make your offer, you'll already know. If they just say seller's offering a home warranty, then you've got to call the agent up and say, well, who gets to select that? Is the seller got one in mind that they're going to pay for? Or
price too.
Right. And then how much are they willing to pay? But anyway, this last one block here is to say how much not to exceed, because there are varying degrees of policy, right? You can get enhancements or something like that. So you've got to make sure to put the price in. So the property disclosure form, this is just basically saying that they've received it or they haven't. And if they're exempt from providing it, this is obligating you pretty much to use the form that's been created by the board that says that the property's exempt, like new construction or something like that. Buyer's off-site acknowledgement. So this is, when it talks about off-site acknowledgement, it's talking about those things that the buyer needs to do their due diligence on that aren't directly related to the property in terms of just the building, so it's not the inspection. It's talking about things like zoning issues, any issues with school districts, their ability to use the property legally the way they want to use it, like multifamily or single family or however else. If they've got any issues relative to wanting to know about the sex offender registry, any noise. So anyway, this just basically tells the buyer, again, it's for clarity, making sure they understand what their obligations are so they don't come back and say, well, the seller should have told me or somebody should have told me. It says, buyer, here's the things that you've got to do. This is your opportunity to do it. Now, the next one is the big one, which is, like I said, this is the real estate inspection contingency. And if you see, it has all been struck through.
Oh, wow.
So the whole the way they wrote it before, they decided just to start over, and they were going to write it again. So when we get on down to the new stuff. So basically, again, it starts off by saying, buyer, this is your responsibility, right? If you want to know something about this property, here are the rules, here's what you've got to do. And that it is at the buyer's expense to pay for all of these things. And as you probably know, Ohio finally completed their enaction of the license law that requires home inspectors to now be licensed. It also requires that you, as real estate agents, must refer licensed home inspectors, right? And when you do so, this contract doesn't say it, so this is kind of an aside, you must refer a minimum of 3 licensed home inspectors. So you just can't say, give somebody one card and say, here's a home inspector, you'll like this, and you have to give them 3 names. So by law, this is what you have to do, you have to give them 3 names. And basically, it goes on to say what's in bold there is the buyer's relying solely on buyer's examination, either personally or through their home inspector, right, to decide whether or not the property meets their needs. Now, when it comes to the licensed home inspector, they're not required to use a licensed home inspector. They can still use somebody else. They can use their father, right? They can use Uncle Joe. But they're still going to they're going to rely on wherever they get their information. This is notice to them that that's on them, that they can use them. But now, if it's they can also use people who like licensed HVAC, if that's the main concern, or termite inspector. Those also qualify as home inspections. But again, it's up to the buyer to choose what types of inspection, how many they want, what types of professionals they want to use, what licensed professionals, unlicensed professionals. It says that the seller basically has to make sure that inspectors and contractors are permitted access to the real estate at reasonable times. And you have to give them reasonable notice. And while they're there, they are allowed, per the contract, to take any kind of photographs or video that they may need to take. So the contract's saying that they have the right to go in and do that. It also says that the buyer is acknowledging that they understand that the home inspection is not about bringing the property necessarily up to code, that are up to codes that are not applicable in the area. So if there is a code and they're not up to code, then the home inspector would pass that law, as long as it's about this, it's the code for the area where the property is located. It can't be some national standard. In other words, it has to be more localized in terms of the standards that are used. But I think they kind of use a national standard with the building codes anyway. But, and it's, lastly, it says buyer understands that except as may be further agreed in writing, so here's an opportunity for an addendum, seller is not required to make any corrections that may be noted in the inspection report. Now, the other thing this paragraph does is it points out to the buyer that this is about defects in the property identified as part of the inspection. It's not about cosmetics. It's not about necessarily even workmanship. It's like somebody should have done it differently, or somebody else could have done it better. That does not qualify, and this paragraph is intended to make sure that they understand that. It says buyer understands that the inspection report may include notes which are for informational purposes only and do not reflect the condition of the property. The goal here in rewriting this is basically to not allow the inspection contingency to be an easy out. They have to identify specific defects. And it also says, and I'm not sure where it says, I might have passed it up, that they have to provide, so if there's going to be repairs that they're going to request, they have to provide the excerpts from the inspection report that shows that this is what's defective, right? So you're going to have to substantiate any repair request with the documentation that it was actually identified as a defect. Of course, it says buyers shall be responsible for any damage to the real estate that's caused by themselves or the inspectors. That's always been the case. The buyer understands and agrees that the inspection reports are not to be considered a list of required repairs and or corrections to the real estate, but understands that the inspection may include the notes. Okay, so that's where I want to make you aware of where that language is found. And then now we get down kind of to the terms that control this, which is basically, you know, the buyer has to say whether or not they've received the lead-based paint disclosure and the pamphlet to protect your family from lead in your home. So they're going to have to denote yes or no. Notwithstanding anything to the contrary herein, certain loan types may require certain inspections. If so required, buyer and seller agree to comply with lender requirements. So another opportunity to remember when you're setting those initial financing contingency deadlines, depending on the type of loan that you're dealing with, FHA, VA, if there's going to be some repairs that are required, you got to factor that timeline in to the closing date at minimum and the clear to close, right, that you have to provide them with, that they have time to get those repairs done. The buyer has the right to waive the right to conduct the inspection. So they don't have to do this, but if they elect to do it, the next line says that they can do a limited inspection, and this is where they choose one of the types here, they're calling that limited, so if it's going to be termite, wood-burning insects, lead-based paint, or you can write in another, so maybe it's an HVAC. But if it's not going to be a whole house type of general inspection, or you're reserving the right to do any kind of inspection you want, then you're going to use that category to specify the limited areas. And of course, again, in this market, with buyers wanting to, you know, stand out from the rest, many people are waiving inspections altogether. So you might not be waiving all of them. There might be a few that you think that you have to put in there. That's where you'd use this. Otherwise, this is the full inspection clause there. It allows the buyer to get any type of inspection that they might want. So here are timelines again. You're going to put in how many days that the buyer has to complete the inspections. Keeping in mind, of course, again, that there are going to be notices you have to provide, and within that inspection period, you also have to get the inspections done and provide whatever notice is going to be required. Which is the first option is that you provide the seller a signed written request for seller to correct any material defects, material conditions, or matters adversely affecting the real estate. So this is the defect notice. And this is where it talks very clearly about what it can and can't include. So the defect notice shall identify the conditions to which buyer is requesting correction. I'm trying to go back and forth here, and I'm gonna have trouble keeping up. Okay, so identify conditions to which buyer is requesting correction by seller, and shall include the relevant portions of the inspection report which describe the conditions to be corrected. So again, if it's Uncle Joe just can't come walk through. Uncle Joe's going to have to write a report, right? And that report is going to have the excerpts of it, not the whole report, just whatever relates to the repairs that are being requested. You have to do a little snippet, cut it out, and attach it to your repair request. And then in bold, buyer agrees that minor routine maintenance and cosmetic items are not to be considered material, and buyer may not object to these in the defect notice. So again, you're going to have a lot of education of your buyer when they go see a home, to talk to them about, you know, when they raise their nose at something, and they're going to have it looked into. If it's just going to be cosmetic, make sure they understand that cosmetic doesn't count. It's going to have to be some kind of defective condition of the home. So that's the first option. They can ask for repairs. They have to attach a copy of the report that shows that this is a defect. Or B, they can just say that they're satisfied with the condition of the property and they can take it as is. Again, no matter which way you go, you've got to give written communication to the seller. If you're asking for repairs in writing, of course. If you're not going to ask for repairs, you're supposed to put that in writing, because that ends the timeline for the inspection period. So you've got to have some documentation that the timeline for ending the repairs is over and you've moved on to the next phase. Now, what this says next is B, that in the event that the buyer has given the seller notice of inspections that are due, that the seller then has blank number of days to provide a response. So the seller cannot just sit back and do nothing anymore. You're going to have a specified number of days that the seller must respond. And if they don't respond, saying they're either going to correct or they're not going to correct, it's going to have some consequences too, because this is requiring them to provide written response to the repair request. And the reason is because all of these stages now are timed, and they're timed by you've met the period by giving the documentation that period's over. So the seller is supposed to give a written response, either accepting the repair request or saying I'll do this and not that, within a certain number of days. And then of course the next period, is to negotiate. Now they're calling this a counter offer by the seller. So whatever the response is, either I'll do it or I'll do some of it, or I'm not going to do any of it. They're considering that a counter offer. And of course a counter offer means it has to be accepted by the other side, right? So C says that in the event that the seller has timely delivered to the buyer a written counter offer, no matter what that offer is, the parties have how many days now you're going to put in there. You have a blank number of days to do this negotiation. It says to reach a mutual signed written agreement detailing seller's correction of defects, if any. In the event that the parties fail to reach a mutually signed written agreement under this section, this contract shall automatically terminate. Seller comes back and says, no, buyer, you take it as is. The buyer can say, no, I'm not going to do that. They haven't reached an agreement saying basically the contract's going to go forward, therefore it automatically terminates. So it says, notwithstanding the foregoing, this section 14B provides limited circumstances in which a buyer may elect to not provide a defect notice, and then the buyer can terminate the contract. So this is a little different. So this is saying that there are some limited circumstances where the buyer doesn't have to say, here are the defects, and I'm terminating the contract. They can terminate the contract without providing the defects only if it relates to structural integrity of the buildings, the presence of asbestos, presence of lead-based paint, and the presence of any other hazardous materials as defined below. So if it's any other type of repair, they've got to attach the inspector's report and say, I want you to make these repairs. They don't have to ask for repairs in order to get out if it relates to these items here, but these specific items only. Now the curious thing for me is this hazardous material, because that's what it says, means substances defined as hazardous substances, hazardous materials, are toxic substances under federal, state, or local law. So guess what, guys? You're getting ready to engage in the unauthorized practice of law because you've got to find some document out here that tells them what the federal, state, or local government defines as hazardous substance. And just to check it out, I went out and thought, well, mold's a big deal in homes, right?
Yeah.
Right.
You know, buyers find mold in homes, they don't want it, especially if they've got young children. I couldn't find anywhere where the federal, state, or local government defines mold as a hazardous substance. Not where they define it as a hazardous substance. I found lots of material about how hazardous it is to your health. But where it's regulated as to how much you can have, only as relates to getting the air tested, right? But getting the air tested doesn't necessarily disclose the fact that you see the mold here and it might be behind the wall, the drywall, right? So lots of new work for you guys. I keep going back. There's a lot more responsibility here. So I would, you know, when it comes to this, if something like mold, you're going to need to make sure it's well documented in the inspection report. And you're going to have to attach something that says that it's in there in order to get it covered, to give your buyer the right to terminate the contract. Now, that's my opinion. I could be wrong about that because, like I said, I was in preparing. I thought, let me just go out here and test to see if I can find that mold's a hazardous, and I could not find anything that said, you know, regulation such and such mold hazardous.